Your Lordship, may I make a mention regarding item 13, hearing item, my Lord.
Yes.
This writ appeal, senior counsel is appearing from Guwahati, so he could not come this time, Your Lordship. If it may be taken up after 2 weeks, my Lord.
For the appellant?
For the respondent, my Lord. For the respondent,
Who is the senior counsel?
PJ Saikia, my Lord. He is the one who took up the matter before the single bench.
He could have come virtually also.
I have been informed that, my Lord, he could not be available within this week, and he's not sure for next week also, my Lord.
We cannot have a court depending upon the timetable set by the lawyers.
I understand, Your Lordship.
No.
Since he is the leading counsel, I am having problem, my Lord.
You see, there is a notification issued by the High Court. He knows it very well. That if you're going to ask for adjournment, you've got to ask for adjournment 1 day in advance. That also in writing, there's a form. He's the senior counsel, he should be knowing it. Otherwise, what you do is that you leave us working, we read this at night, we come prepared, and then you ask for time. So I don't think we can allow, just for your convenience. There's a certain procedure to be followed. You follow it. Why do you make us work?
Or at least by next week, my Lord. Then I'll speak to him again, whether he could.
Let us see you speak to us around 2 o'clock. Let us see.
My Lord.
Next.
Yes, Your Lordship. I see court indulgence in mentioning Part 2, item number 12, on behalf of Miss Mary Elkhiangte, Your Lordship.
Again, same thing. Or do you want adjournment? Why?
She's on leave, Your Lordship.
She's on leave.
Yes, Your Lordship.
You should have told us, no? 1 day beforehand. Acha, the problem is that cause this is
Cause list we received only after 5 o'clock, Your Lordship. So it's quite difficult to inform beforehand.
okay. Right, on the prayer made for adjournment on behalf of Miss Mary Elkhiangte GA. This is the matter after?
After 2 weeks, Your
After
Lordship.
3 weeks.
Oblige.
My Lord, with regard to item number 10, with the consent of both parties, if the matter may be taken up tomorrow, my Lord.
Item 10.
Yes, my Lord.
Okay, tomorrow.
Oblige.
May I seek your lordship indulgence in mentioning item number 11, my lord. I'm appearing for the appellant. However, my senior, Mr. Caesar Ramchana, is unable to attend today because of some personal difficulties. So, my lord,
Who is he? Aram Chana is appearing for whom?
The Mizoram Rural Bank. So, may the matter be taken up day
Item?
after.
Item?
11. Hearing item number 11.
Item 11 is a criminal appeal.
Hearing list or today?
Hearing list or today's list?
Today list, my lord. Today hearing.
That's a POXO matter.
No. Writ appeal DB list item number 11.
Not the hearing list.
Writ appeal 1 of 2025.
Mentioned for details like this one. He's mentioning for that.
Acha, you mean part 2 list?
Not
No.
part 2, DB. DB item number 11. Today's
daily
list. Daily list, sir.
Daniel Lal Machwana, this case.
No, my lord. Mizoram Rural Bank and others versus Srimati Rimoy and others. Item number 11 of today's DB list.
Just now it was mentioned. The respondent said.
My list and your list is different. Look, I have got this.
Part 1 hearing list, my lord.
Which one is it?
Oh, that's fine. Different. It's 20th. Tuesday.
I don't know. I've been given a different. My list and my brother's list is different.
See.
So we'll adjourn the matter, your matter, because probably I have not read the file. I have read this item 13 here. This is with regard to whether the Provident Fund money can be forfeited for recovery of the embezzled amount. So that is not your case.
That's not my case, man. I'm so lucky, my lord. I'm much obliged.
What have I been reading? I don't know. So those are the files that was given to me.
See.
Anyway, we'll take it. Okay, we'll adjourn the matter. Item 13. On the prayer of Mr. Bilal Ramena, who submits that the senior counsel, Mr. P.J. Saikia, for the respondent, seeks adjournment, list the matter after 2 weeks.
Highly obliged, man.
Yes, my lord. With regards to item number 11,
What is the item 11 about?
writ appeal 1 of 2025.
1 of 25.
Yes, my lord.
Yes, this is the one I've mentioned just now. This,
I'm mentioning on behalf of Mr. Caesar Ramchana for may the matter be taken up day after tomorrow, Thursday,
Why day after tomorrow?
because he's having some personal difficulties and cannot attend.
Okay, who's
today.
for the other side?
Senior counsel, Mr.
Mr. Ramzawa, any
C.R.
problem?
Ramzawa.
Day after tomorrow?
Day after tomorrow, Lord.
Uh-huh.
No problem.
Okay, right. On the prayer for adjournment made on behalf of Mr. Caesar Ramchana, list the matter day after tomorrow.
Much obliged.
I cannot rely on this one.
May I also seek your lordship indulgence in mentioning item number 14? Item number 14, my lord.
14.
Yes, my lord. I'm
That
appearing
is matter relating to?
it relates to criminal appeal, my lord.
Under what section?
Lordship, my senior instruct me to mention
What is the case number? Case number?
case number criminal appeal 18 of 2025.
18 of 2025. Okay, 22C.
Yes, my lord. If the matter may be taken up tomorrow, my lord. My senior is having personal difficulties today.
Who is the senior?
Johnny L. Tauchang.
Okay, right. On the prayer made on behalf of Mr. Johnny Tauchang, list the matter tomorrow.
Much obliged.
May I plead your lordship?
Yes?
Lordship, I beg to mention item number 7. Kindly fix the matter on 22/01/2026.
Why?
Lordship, my senior, the engaged counsel, wish to appear physically.
Appear physically, okay. Okay, right. Item 7.
7, Your Lordship.
Okay, on the prayer made on behalf of Mr. S.K. Medi, list the matter on 22.
Much obliged.
For omission, item 1 and 2.
My lord, item 1 and 2, if it can be passed over for some time, my lord, they are on their way.
Item 3.
Now, this Lunglei land, though
Yes.
that the land had been identified and it had been handed over to the judiciary, now the bar association out there have identified a new, yes, better plot of land, it is. And it is, I believe, with the government. So we will adjourn the matter. What is the thing, where is the letter now? Where is the file with regard to this land? Yes, Mr. Additional AG, any idea?
No, my lord, I have no instructions of now.
What are you doing? You don't come to court and say that I need instructions. You should have had instructions from before. You will list it day after tomorrow. You get the instructions by then. Right. It has been stated at the bar that there is a proposal sent to the government for exchanging the land that has been allotted to the judiciary at Rasiven, Lunglei, with the land on which a building for the printing and stationery department had been made. Mr. Samuel says Ashanta Additional AG shall obtain instructions with regard to the same. List the matter day after tomorrow.
Item 4.
I believe it's with the CM. You just find out. Yes.
Lordship, as per my limited information, they have completed the work, but the completion certificate has not been
Madam, if
submitted
they
to
have
the court.
completed, that's enough. Who are
Yes,
you to
Lordship.
insist for a completion certificate? Yes, madam.
My lord, yes, the work was completed during the month of December 2025, my lord.
Okay, right. Heard Miss Rosalind Elma, learned counsel for the petitioner, and Miss
Valentina Laldinpuye.
Valentina Laldinpuy for respondent number
4, my lord.
4. Ms. Linda L. Fumble, additional AG, appears for the state government. The PIL has been filed due to the respondents not completing the contract work for construction of a double-lane built-up steel girder bridge over the river Tere. Wide work order dated 24/7/2017 within the contractual period provided in the agreement executed between the parties. Pusa. The last extension of time given to the respondents, respondent number 4, was till 31/12/2025 for completing the construction of the bridge. Next paragraph. The councils for the parties submit that the construction of the bridge has been completed in the month of December 2025. Next paragraph. In view of the submission made by the council for the parties, the present PIL stands closed.
Obliged, Lordship.
Obliged.
For orders, item number 5.
The first order, I had it.
My Lord, this is condonation of 321 days delay. However, my Lord, service of AD return is awaited from respondent number 4 till date, my Lord. If I may permit it, the first step may be taken.
What is the matter about, madam?
The matter is the landed single judge allowed the family pension of the deceased to the second
Yes.
wife.
Any
not
objection
legally.
to the delay? You are appearing for the second wife.
Yes, my lord, I have submitted my objection.
You see, when we peruse the issue is this. The first wife is being given the first pension, correct?
From the Assam Rifle, my lord.
Correct.
But
And the second wife is being given the second pension.
no, he is not given, my lord.
She is going to be given by the
My
order
lord.
of the single bench.
My lord.
Now the issue is, which you see, this person, your husband, your deceased husband, he's a Hindu.
He's a Christian.
He's a Christian. In the Christian, under the Christian Marriage Act or under the Christian faith, are you allowed to have two wives?
My lord, before getting married with the second wife, he was a Hindu. Then
He was a Hindu.
yes, my lord.
And then he changed his religion and he had a
And
second
yes.
wife. So
He got married with the second wife.
No,
and-
Mr. Counsel, there are two aspects to this.
My lord.
Whether a Christian can have two wives.
After becoming a Christian, he has only one wife, my lord.
Oh, and what happened to so once he
The
once he
first wife was,
once he converts to Christianity,
Yes, my lord.
he automatically is divorced from his first wife. Is it? Is it your case?
Yes, my lord. And my lord, at the time of joining the Doordarshan Kendra also,
Look, we have got all the sympathy for you.
My
All the sympathy for you. But the problem is that you have got two wives. And any marriage during the subsistence of the first marriage, any second marriage during the subsistence of a second marriage is void. Simple as that.
And my lord, one simple thing that has to be taken note of is that even though the respondents are intending to give 50% of the family pension to the first wife,
No.
they don't know the whereabouts of that the respondent number 4.
Doesn't matter.
They
Whether
cannot-
you know, don't know, doesn't matter. It is very easy to know. If the first wife is getting the pension, family pension, with regard to his service from the Assam Rifles, it can be easily found out, not difficult.
The Assam Rifle also, my lord, there were
Doesn't
some
matter, Mr.
official
Law.
communication.
The law is the same. Whether you don't know where she lives or whether she's getting, the law remains the same. Under the Hindu Marriage Act 1955, a marriage between Hindus is sacred. It's a sacred union. And unless there is a divorce granted as per the Hindu law, you cannot have a second marriage. You cannot even convert and have a second marriage. Under the Christian Marriage Act or under the Christian law, if you can show me that a Mizo can have or a non-Mizo can have or anybody can have more than one wife, we'd be glad to learn the law from you. Show us. There's none. One thing is clear, that because your children can get a part of the pension as per the 1972 CCS pension rules. Part of the pension you will get. We will not even disturb the DCRG, all this, because those are by what? How have you been given? You have been nominated for that. So, but then with regard to pension, you cannot. You can get at the most, your children can get 50%.
My
That's
Lord,
it. You cannot get any amount.
My Lord, what about the other part?
The
50% part?
50% of?
My Lord, yes, of the pension.
50% not to you. The wife cannot get.
Yes.
Because you are not the wife. You'll never be the wife. Legally, you are not the wife. Practically, you might be. You'll be like the girlfriend type, concubine. But
yes.
then you're not the wife. Legally, you're not the wife.
And
even as per the law, as per the conduct rules of India, a government servant cannot have more than one wife. Even if you are a Muslim. As per the Mohammedan faith, you can have maybe 4 wives. But as per the Indian conduct rules, a government servant can have only 1 wife, not 2.
My Lord, even in that case, my children should be given 100% of the family pension because the whereabout of the first wife is not known by the respondent.
We cannot change the law unless you say that your submission should override the CCS pension rules 1972. You see, you can say that you might be saying that the water in the ocean is not black, but it is pure white. Doesn't mean that it is true what you say. You have got to show, you have got to prove it. There has to be a basis for saying that. You cannot say that I am having blonde hair or something like that. Even if you say it, you have got to prove it. So we'll allow the condonation of the day, 21 days. We're not in agreement with the learned singleton. This is completely wrong, in violation of the Supreme Court judgments. So many Supreme Court judgments are there from the state of Bihar.
My Lord, one thing. With regard to the recording of the wife and the children, at the time of joining the Doordarshan Kendra, the petitioner, number 1, was recorded as a wife. And
so what?
The respondent number 2 and 3 are the children.
Just because he has not put his first wife's name does not mean that the first wife is not his first wife. When you yourself have admitted to the fact that she is getting the pension for the services done by him under the Assam Rifles.
My Lord, I mean to say that the family details submitted by the deceased had already been accepted by the respondent authorities.
Accepted. If they tell a lie, you see, he was in the Assam Rifles. He finished he resigned, he retired from the Assam Rifles. Then he joined Doordarshan.
Right.
Now in Doordarshan, if he doesn't say about his past, what will do? They will believe him. Just because you hide certain facts doesn't mean that what you hid is not true. You are hiding certain facts. You are telling a white lie or a black lie. I do not know what, but it's a lie anyway.
And my Lord, regarding the DCRG, I am the nominated person, the first wife, the second wife, and my children. How can they make a decision to give the DCRG to the person who is not nominated?
You see, there is a Supreme Court judgment which says that the nominated persons are the persons who are only entitled to receive the amount from the government and the custodian. And the distribution of that should go as per the succession law or the rules that are provided for distributing that amount. If you want, we'll throw out all that also. Then you'll get 0. That is, I forgot the citation. It is there. So on all fronts, we do not agree with the findings of the learned singleton. How can it be? You know? Where is your averment that he is a Hindu, that he converted to Christianity? And how did you marry under the Christian Marriage Act? He's a Hindu. What is his name?
Dal Bahadur.
Dal Bahadur.
Yes, yes.
Now Dal Bahadur became a Christian. Did you marry under the Christian Marriage Act?
Yes, after getting divorced.
You married
from
under the
first
Christian
wife.
Marriage Act?
Yes, my lord.
Let us see what the single judge has said. According to the petitioner number 1, that is you, although their marriage was not officially solemnized, not officially solemnized, but the bride's price was paid as per local custom. Where? You are not even married under the Christian Marriage Act. He is not a mizo. Where does custom apply to him? On all fronts, there is no case. Right. Heard Miss Zainab Safi, then at CGC. Also heard Mr. Lal Chandana Khyante, Learned Counsel for the respondent number 1, 2, and 3. This is an application for condonation of 321 days in for the delay in filing the appeal against the impugned judgment and order dated 13/8/2024, passed by the learned single judge in WPC 96 of 2022, wherein the learned single judge has directed the family pension payable, the family pension to the petitioner number 1 for the services done by the petitioner number 1's husband, Mr. Dal Bahadur, Shri Dal Bahadur, on the ground that in the family declaration given by Shri Dal Bahadur, the petitioner number 1's name has been recorded along with petitioner number 2 and 3, who are the children of Shri Dal Bahadur and petitioner number 1. I'm not petitioner, it will be out here respondent. Respondent 1, wherever we have said petitioner, make it respondent. Further, the respondents number 1, 2, and 3 should also be given the DCRN as per the nomination in the family declaration. The said direction passed by the learned single judge had been made on the ground that the first wife of Shri Dal Bahadur, who was receiving the family pension for services rendered by Shri Dal Bahadur as an Assam Rifles personnel had not been recorded, the name of had not been recorded in the family declaration made by the government servant while working for Doordarshan. Full. The Learned Council for the applicant submits that when Doordarshan Kendra is all, as security guard. Okay. Submits that when Shri Dal Bahadur had concealed the name of his first wife in the family declaration while working for Doordarshan Kendra, the same could not be a ground for denying the service benefits / second family pension to the first wife. Further, the marriage between Shri Dal Bahadur and the respondent number 1 would be deemed to be null and void during the marriage of, as the same happened during the marriage of Shri Dal Bahadur and his first wife. As such, the second family pension could not be given to the respondent number 1. Full stop. The Learned Council for the applicant submits that a grave miscarriage of justice would occur if the application for condonation of delay is not allowed. Full stop. She submits that the impugned judgment and order was passed on 13/8/2024, and the same was sent to the Deputy Director. The same was sent to the applicant number 3 on 16/8/2024. The same was received by the respondent number 3 on 19/8/2024 and forwarded to the DDG bracket admin, Guwahati Zonal Office, on 22/8/2024. Yes, sir. Clarifications were sought for on 23/8/2024. And a reply was received by and a reply was received from Doordarshan Kendra on 3/9/2024 by the Deputy Director General, Admin, Guwahati Zonal Office. When you take this, para 9, 10, 11, take till para 19, 20 also. No, first one. Then carry on. Then various other communications were made thereafter, which is reflected from para 9 to para 36 for the delay in filing the appeal. The same shows that there had been many communications made between the various offices. We are aware that, next para, we are aware that delay should not be condoned simply on the reason that there are many desks which have to be gone through in a government office prior to filing an appeal. It is no doubt true that the grounds of delay should not be different for a government office and an individual. First of all, however, there is also another aspect to the same, inasmuch as when we look at the merits of the case, we find that we are of the tentative view that a gross miscarriage of justice may take place if the delay is not condoned. In this respect, we would like to refer to the judgment of the Supreme Court in the case of Lipokao versus State of Nagaland, and in the case of Emperor so-and-so Dasha, where it has been stated as follows. Next. In view of the facts as stated above, and keeping in view that there is no averment made by anybody that the first wife has expired or died, or that the marriage of the respondent number 1 with Dal Bahadur, Shri Dal Bahadur, had not been made during the subsistence of the marriage of Shri Dal Bahadur and the first wife, we are inclined to condone the delay of 321 days. The delay is accordingly condoned. I is accordingly disposed of. Now, come to the main case.
My Lord, the hearing of the main appeal may be taken up after some time.
No, there's nothing. It's your case. You are the writ petitioner.
My Lord, the writ appeal does not contain all the
doesn't have to. We look at your writ petition also. It's here.
So, my Lord, I am not prepared for the final hearing.
Tomorrow. This is the matter tomorrow. On the prayer of the Council for the respondent number 1 to 3. 1 to
1 to 3.
1 to 3. Who's for 4?
For my Lord, service is not completed.
First wife.
First wife.
Doesn't matter.
Obliged.
Acha, in the beginning, right? No one appears for the respondent number 4. That is the first wife. How in as much as service was not complete against the respondent.
For hearing, item number 8.
Item number? What is that? So, Moto, Vedin Chan Mari. Yes, madam.
Yes, Your Lordship. As per the last order on the 14th of 7/2025, I was instructed to obtain instructions as to whether the task of detecting and penalizing vehicles parked without valid garage arrangement was conducted by the Transport Department or not. And accordingly, Your Lordship, I had submitted an affidavit on the 10th of September 2025. Which entails that, Your Lordship, initially between the year 2000 till the year 2017-2018, the Transport Department was entrusted with that responsibility of checking vehicles without valid garage arrangements. However, Your Lordship, after October 2020, that responsibility had been entrusted to the local council within Aizawl, Your Lordship. So that is as of now, Your Lordship, the duty of checking.
It has been entrusted to the local council?
Yes, Your Lordship.
By whom?
Your Lordship, a meeting was held on the 23rd of October 2020 with the AMC and the traffic police.
2020?
Yes, Your Lordship. This was in.
That was how many? 5 years ago?
Your Lordship, yes, Your Lordship. So after the pandemic, Your Lordship, the arrangement was such that the local councils have been given the responsibility of checking and penalizing.
Where is the document giving them responsibility?
Your Lordship, they have not, the state does not have an official annexure of such, but
Then
it has
how
been
will-
admitted
how
in
will
the
they know?
affidavit.
Did you call? Who was there in the meeting? Which local councils were there?
Your Lordship, to that regard, I have not been given any document, but the statement has been given as a form of
By whom?
affidavit.
Statement made by whom?
This is, Your Lordship, given by the Secretary, Transport Department, Your Lordship.
Should we call the principal secretary to explain to whom he has given the instructions and where is the instruction? Is it a verbal instruction? How many local councils are there in Aizawl? Any idea?
Your Lordship, I do not have the definitive numbers.
This is all hogwash. Just trying to pull the wool over our eyes, that's all.
Your Lordship, if I may be
We'll
given
give you an ultimatum if you want.
a day's time to gather the documents wherein they had officially entrusted the responsibility to the local councils.
You see, Aizawl roads now, everyone is parking their two-wheelers on either side of the road. Chan Mari also now. I mean, you can hardly move now. People can hardly walk. I think you should start moving these vehicles. You cannot have two-wheelers on both sides of the road. You tell your transport secretary
Yes, Your
that
Lordship.
if they don't act, we'll call them here. We'll sit there. We'll sit here for 2-3 days, sort it out.
Yes, Your Lordship.
It's an issue which I'm quite sure he will also want to solve.
Yes, Your Lordship.
But the problem is that no one is really applying their minds and they are scared of hurting the feelings or whatever, I do not know. But that is not the way a city should work or should function. all the roads are getting blocked by parking, unauthorized parking, and AMC is only wanting money to make parking fees. We'll close down some of the parking places. You have to close down. You got to talk. Otherwise, there's no movement possible now. So, what are you going to do?
Your Lordship, if time may be granted, I will, a meeting can be held and also instructions may be sought again.
No. We will give you maybe 1 day's time or something. That's all. You will not do anything in 2 weeks. Neither you'll do in 1 month. Unless we give you some shock treatment, you are not going to do anything. You give us the notification
Yes,
by
Your
which
Lordship.
you have entrusted the local council. Now, will the local council, is it their job to do traffic? Can they give challans?
No, Your Lordship.
Can there be uniformity in the parking, where you should park, where you should not park? It will depend upon the likes of each local council. Supposing a person doesn't obey the local council, what can the local council do? Can they impose fines? The government, the transport department had issued a circular earlier that only persons who have garage facilities would be able to have their vehicles registered. And it was the local councils who gave them the certificate. And for one, I'm quite sure for 5-6 vehicles, they must have identified one garage or something like that. You cannot pass the buck on to somebody else. You have got to take a stand. Right.
My Lord, if I may raise one additional point,
Yeah.
my Lord. My Lord, the respondent number 1, UDNPA, my Lord, they had come up with a scheme called PAHOS, my Lord, Parking House Support Scheme. And as per the assembly record, my Lord, which we have online, my Lord, they had spent around 11 crores with respect to this scheme. Now, my Lord, we are not seeing anything after this scheme was implemented. They had given money, my Lord, but looking around, my Lord, we have not seen any PAHOS.
Have they given
parking.
the list of persons who have been
My
given
Lord,
this
for
powers?
that is one prayer I want to make, my Lord. Will it be possible, my Lord, to direct the respondent number 1, my Lord, to give the list?
Yes, why not? In fact, you know that church near Dorcon,
Yes.
while you go up, a Burmese church, full of, Burmese church. There was an extension made, what I heard, I don't know if it's true, for parking facilities. What parking facilities? It's become part of the church now. This is being done in the name of the church. Because church is also made up of all humans. And to err is human. You get the notification by day after tomorrow?
Yes, Your Lordship.
Mr. Joseph L. Rentley, Learned Counsel for the Learned Amicus Curiae submits that to ease the burden of parking in the city, the UDNPA department had come up with a scheme for it is a loan or what?
It's a scheme, my Lord. I'm not sure how it operates, my Lord. I will it's for garage. They are supposed to build garage.
Okay. What have I said? a scheme for providing money to land/building owners for providing parking space to the general public. And in lieu of the same, huge amounts of money, in lakhs, were provided to those landowners, land/building owners. He submits that, as per his knowledge, approximately rupees 11 crores
11 crores.
have been used by the UDNPA department. Full stop. In view of the submission made by the learned amicus curiae, the UDNPA department, the secretary to the government of Mizoram UDNPA department is directed to submit an affidavit stating the exact number of money that had been utilized for undertaking the PAHOS,
PAHOS scheme.
PAHOSS.
Correct, my lord. Parking house support scheme.
PHOSS scheme. The affidavit should also contain the names of the individuals and the amount of money given to each individual under the PAHOS scheme. The affidavit should also contain the guidelines and the parameters to be followed under the PAHOS scheme. Full stop.
And my lord, the list of individuals who have actually constructed.
The next para. The affidavit should also contain a submission with regard to whether the UDNPA have carried out any inspection over the buildings constructed under the PAHOS scheme for parking, and to see whether those buildings are being used for the PAHOS scheme. The affidavit shall also contain the owners and the buildings which have not followed the guidelines of the PAHOS scheme despite receipt of money by the land/building owners. Further, if the PAHOS scheme has not been followed despite receipt of money, what steps has been taken by the UDNPA for recovery of the said money given to those beneficiaries? Next paragraph. In relation to the order dated 14/7/2025 passed by this court, for checking/inspection of vehicle garages subsequent to the order dated 13/9/2023, Ms. Lalnun Louis, Learned Government Advocate, submits that the responsibility of the same has been given to the local councils within Aizawl city. Ms. Lalnun Louis shall produce the official government order/circular directing the local councils of Aizawl city to conduct checking inspection of vehicle garages subsequent to the order dated 8/30/9/2023. She should also obtain instructions as to whether the exercise to be conducted by the local councils would have to follow certain guidelines laid down by the government, or whether the local councils would have the liberty to make their own guidelines, in which case the issue of uniformity would also have to be addressed. List the matter tomorrow. Day after tomorrow.
Obliged.
Much obliged, Lordship.
That the UDNPA's, the affidavit to be filed by the UDNPA department shall be filed within a period of
Your Lordship, if 3 weeks time may be granted.
3 weeks time. 3 weeks.
Obliged.
Much obliged.
This is the matter. They have to come.
Item 9.
lord, those are the original copy of land passes and their connected documents in respect of 12 petitioners and respondents, my lord.
12 petition respondents,
Yes, my lord.
in both the cases?
Yes, my lord, both the cases. My lord, the problem is that they have started computerizing all the documents. And in that process, they have lost some of the documents and some
No,
are
I
kept
doubt.
elsewhere.
I doubt. These are all false. Appears to be false.
No, my lord, they are still trying to find it. They'll produce it, my lord.
Out here it says Boina Umlo. If there is no Boina, what do you mean Boina Umlo? And how are they claiming Assam rifles then? Boina Umlo means there is no problem. How are they claiming double then?
What basis?
What basis? Look, there is no the border witnesses. The witnesses for the border has to give their signatures for no objection. There is no signature of Assam rifle.
Only in one pass, my lord, there's no objection.
No, that will also again have to be proved. Because, you see, there is no... So from where does this come about? It must be some other land. In 1974. The problem is they are not illegal. Look at this pass of 60 of 1969. It says here, pass pekni atrangat kuphat. If the pass is not made if the house is not made within 1 year of the issuance of the pass will automatically expire. The in Aladdin Lauchuan have passed nun nahi athi halani. So if there is no house, there is no house. Is there a house? If there is no house, if it's some rival land, and if there is no house, then it died automatically in 1969 or in this was issued in 1969. How can a land settlement be given, land settlement certificate be given on a expired house pass? Because it died a natural death. One example. Then, this is for Lal Thanzawa. Is Lal Thanzawa one of the persons who has surrendered his land pass?
No, my lord, I don't think so.
Acha, what about El Bana, Major El Bana, Sub Subedar Major El Bana? Cancel, because it says here all cancelled. Have they been paying tax, these persons?
No, my lord, not all of them.
Every year they've been paying tax? Who has been paying tax and for which year?
My lord, those persons at serial number 8. Atas ang kape. 8, 9, 10, and 11.
Only they have been paying tax?
Yes, my lord.
In both the cases? In both the cases? 8, 9, 10 and 11 of which case? There are two
My lord,
cases.
I have given the list today. I have made those 12 persons list. With regard to them only, my lord. I'm submitting now. Number 8 is Ram Prasad.
Site allotment order issued in 1981. In Venglui area. That is between Lalzui Thanga's land and AR, Assam Rifle land. A structure must be put up within 1 year from the date of issue of the pass. Though the pass is valid for 3 or 10 years, it's only cancellation. Only a right to occupancy. This is in the name of Dongolian Asylum. You see, with regard to, I think, Ram Prasad Upadhyay's land, already a decision has been made by the division bench of this court. It is, I think, Mr. Ramzava, your case, no? That is Yoga Raja's case, I think. I think that has already been decided by this court. They cannot get beyond what they have. That is different. Ram Prasad Upadhyay, that may be different, I don't know. Yes, where are your other documents?
My lord, they are still searching. They'll produce it as soon as possible, my lord. If it can
Right.
be taken up tomorrow, my lord, the rest.
Okay, we'll take it up, right. Mr. A.R. Malhotra, learned counsel for the petitioner in WPC 31/2020 is present. Ms. Dinari T. Mrs. Linda L. Humble, additional AG, Mizoram is present, along with Ms. Zainab Sampi, CDC. Mr. Siraram Zawa, Senior Counsel, is present for respondents number
49 to 52.
49 to 52.
53.
53. In WPC, in WPC 31. 31 of 2020.
31.
Mr. Lalam Plonga is present for respondents number 58, 59. In 31 of 2020. Ms. Dinariti Aziu is present for respondents 43 in WPC 31 2020. Mr. F. Lalayang Dera is present for respondents number
49 and 53.
49 and 53. Next, right.
And my lord, I'm for 6, 10, 12, 14, 17, 19, 22.
Mr.
Lalbiak Nunga Namte, my lord.
Albiak Nunga Namte is present for various other private respondents in WPC 31 of 2020. Full stop. Next paragraph. Ms. The learned AG, additional AG has submitted a few documents and submits that the other documents are being traced by the department. We have perused some of the documents that have been submitted by her. It is interesting to learn that in respect of the land settlement certificate number 506 of 1974, apparently issued on 13/9/74, the same had been made by superseding the original House Pass number 60/69. A perusal of House Pass number 60 of 69 shows that the said pass had been issued with a definite term and condition therein, which stated that if a house was not built on the land covered by the said pass within 365 days, the pass would automatically expire. It is not the case of the said Lal Tanzawa. What number is he?
Respondent
Huh?
number 30.
Respondent number, bracket respondent number 30. That he has built a house on the land allotted to him by house pass number 60 or 69. The house pass having been issued on 31/1/1969, comma, the house pass, the validity of the house pass expired on 30 January 1970. Despite the same, an LSC number 506 of 1974 has been apparently issued on 13/9/1974. On the basis of an expired house pass. Mrs. Linda L. Fumble prays that the matter may be next para, prays that the matter may be taken up tomorrow to enable the respondents to provide more documents in the meantime. List the matter tomorrow.
Obliged.
This also, this part of thing,
Yes, ma'am.
this file also. Five. Name of lessee. Is this part of your document?
Yes, my lord. That is serial number 3, PHE department pass.
And this also.
Fixed.
Huh? Date has been fixed.
Yes, my lord.
Okay.
And also,
Yes.
my lord, with liberty to avail the proper
Why?
privileges. With liberty to avail the...
Why? Item? Oh, arbitration. This is the one. Okay. They gave me the wrong file. Okay, right. This extension, you are asking for extension of time.
Withdraw the petition.
I know, but this application is for extension of time. How will it help you if you withdraw?
Apologies, my lord, that I have no knowledge.
Then where is the question of withdrawal? Why should I allow withdrawal?
Because it is placed before the competent district court.
Competent?
District court. It is placed before the district court.
Okay, district court. On the prayer for withdrawal made by Mr.
On behalf of Mr. Larot Puyasala.
What is your name?
Valal Chandama.
On the prayer for withdrawal made by Mr. Valal Chandama. On behalf of Mr.
Larot Puyasala.
Lal Ratpuya Sailo.
Yes, my lord.
On the ground that the matter is pending before the
District
district judge.
Yes,
I
my
got
lord. Yes, my lord.
the application is dismissed as withdrawn.
Obliged, my lord. Formation. Item number 2.
My lord, in this case, I'm appearing for the respondent number 2 to 4. If your lordship give us 1 week's time, we'll be able to file our affidavit.
The issue is you have to file the affidavit.
Yes, my lord.
Okay, Mr. C. Lal Faghzwala, counsel for the respondents number 2 to 4. Submit that affidavit will be filed within
A week.
2 weeks.
Your Lordship, I'm representing the respondent number
Are you
1.
filing anything? Is it required?
I don't believe that it is required, but I did not receive
Okay,
any
Miss
information
one
yet.
SME appears for the state government. This is the first point number 1. This is the matter after a week.
1 week. 1 week.
A week means.
Judge.
Item number 3.
My lord, this case is actually taken up by Mr. Soirema, my lord, and we have only been engaged as local councils, my lord. So, my lord, if I may seek for a short adjournment, my lord, if this matter come up after a week so that he can appear in person, my lord.
Where is he?
My lord, he is now in Calcutta.
Doing what?
My lord, he is having some medical treatment in Calcutta, my lord.
But his name is not here.
No, that's the thing, my lord. Because of the limitation period, he had requested us to file the case. Because section 37, my lord, 120 days, it was going to lapse, my lord. So we had filed it on his behalf. But then,
Okay,
my lord,
right. On the prayer made on behalf of the petitioner's counsel, this is the matter after
2 weeks, my lord.
2 weeks.
Deeply obliged, my lord.
Item number 4.
May I, Your Lordship? I'm appearing on behalf of my senior, Mr. J.H. from Neimoya. He's having some personal difficulties. He's being called in his son's school.
Huh?
He's called in his son's school. So if the matter may be taken up after 2 weeks, subject to Your Lordship's permission.
He's been called to his son's school. Is he going to be called to his son's school for 2 weeks or what? Where is the logic for 2 weeks? I can understand for the day. Is he going to be called tomorrow also, day after also?
If possible, at least 1 week.
Yes, my lord, I have no objection. However, status quo maybe may continue, my lord. Passed in orders 47.
What is the matter about?
The matter is about, my lord, the appellant is the illegitimate son of the deceased, and well, the sole respondent is the daughter of the deceased, and she has maintained a separate family. She got married in 1978. However, the said dispute land was bought by the appellant in 1981 after the marriage. So she claimed the heirship certificate, and so the learned additional district judge dismissed the appeal for being the illegitimate son who has no legal rights. And the learned lower court refused to take the provision under Section 33 of the 2014 Act, as the appellant looked after his said father till his death.
Correct. On the prayer of the parties, this is the matter. When? Don't say 2 weeks, just like that.
After 1 week, if possible.
This is a matter after a week.
My lord, if I may, if TCR may be called, because paper book will be required.
This is a question of law. It's a substantial question of law. It's a regular second appeal, correct?
Yes, my lord.
Okay. In the meantime, registry to call for the records.
Obliged.
Item number 5.
Interim order to continue till the next day. List the matter. After 3 weeks, give a date. After 3 weeks.
My lord,
12 February.
if I may be given a week's time to file affidavit in reply.
Item
5. 2 weeks, Miss Mary is on leave, my lord.
Huh?
Miss Mary, since Miss Mary is on leave, if I may give in 2 weeks' time.
Okay, Mr. Zoram Chana, Learned Counsel for the
Petitioners.
petition is granted. 2
2
weeks
weeks'
time to
time.
file affidavit in reply.
Reply, yes,
This is the matter after 2 weeks.
Obliged, my lord.
Item number 6.
Okay. My lord, respondents are yet to file affidavit, but if they are given, then that may be the last chance for filing affidavit.
My lord.
Because this case is filed way back in 2025.
Way
May.
back in 25.
Yeah,
May.
May. 19 May 2025.
Yes.
My lord, I may be granted another more 3 weeks' time, then I have to obtain instruction again.
Similar prayer, Your Lordship. And I'm
Madam, you write to them a strong letter.
Already sent in the month of May.
You send
2000
another 2 letters. 2, not 1. Okay? If required, send them 3 letters also. Ms. Zaira Sampuri, CGC, and Ms. Vande Siami, Learned Counsel for the State Government, are granted 2 weeks' time to file, 3 weeks' time to file affidavit in opposition. This is the matter of 3 weeks.
Obliged.
Item 7.
My lord, I am for respondent number 1 and 2. I may be granted 3 weeks' time for filing my affidavit.
And you?
We've already filed, my lord, on behalf of
Do you?
respondent 7.
And Your Lordship, I'm representing the state respondent, and I'll be filing my affidavit after a week.
Ms. Zaira Sampuri, CGC, and Ms. Vande Siami, Counsel for the State Government, are granted 2 weeks' time to file affidavit in opposition. This is the matter after 2 weeks.
For orders. Items 8 and 9.
Wait, please, my lords. I appear for the appellant in the matter, my lords.
Yes.
My colleague is before, my lords. My lords, item number 9 is the main appeal. That's the arbitration appeal under section
What is this
37.
matter about?
My lords, this is in relation to enhancement of compensation in relation to land acquisition, which was done for National Highway number 306.
So?
My lords, the arbitral award of 23rd September 2024 has been passed without any evidence whatsoever, my lords. This was impugned before the learned appellate court under 34, wherein my lords, the learned trial court made a submission, made an observation that there is no interference warranted, and therefore, my lords, rejecting our appeal, we are before my lords.
Under what?
If I may just take-
So it is, you have come to this court under section 37
Yes, my lords.
with respect to which?
Impugned order under 34, my lords.
34 which? The 34, there's so many, there are only certain heads under which you can file an
Absolutely.
appeal. Yes, under which head?
My lords, patent illegality, my lords will recall in the Sanyong judgment. In the Sanyong judgment, the Honorable Supreme Court categorically notes that in absence of evidence, no order can be passed. Now, precisely in this case, my lords, what has happened is that there is no exemplar sale deed provided or given by the claimant, and despite that proposition, the order has been passed. Secondly, my lords, even in the impugned arbitral award, there is no reasoning accorded whatsoever in relation to enhancement. I will just show one page and that will clarify the position to your lords. My lords will just have the award of 23rd September 2024. This is annexure 2 at page 53.
Page 33.
Page 53, my lords, annexure 2.
Yes.
My lords, the operative part starts from para 9 at 56. Wherein para 9 the submissions are recorded. Now, my lords, will come to para 11. 1 at 58. My lords has it. I just read it for your lordship's convenience. Having considered all these critical assessments upon provisions of relevant act, analysis of judicial pronouncement elaborately discussed, and in particular the most pragmatic position coming from the apex court in arriving at a price agreed upon between a willing purchaser and a willing seller in an arm's length deed, and the price which it would fetch in an open market would be the ultimate clincher, and they have the golden thumb rule. May I just pause here for a moment? My lords, in the entire record of the Honorable Arbiter, there is not even a single exemplar sale deed, not even a single document to substantiate or to make that averment that there was a willing buyer or seller or something similar transaction has taken place. My lords, in fact, in the impugned order. Now, I'll just read out the next part and then I'll take an interim order. I'll show the interim order. Next part is the market of value of the land would reasonably be suitable for the area is indicated below. And then, therefore, my lords, the arbitrator goes on to enhance the prices. There is no reasoning as to why these prices, the prices that were fixed originally, have to be increased. Now, my lords will see the interim order that has been passed in this matter before the arbitral tribunal. That's on, my lords, 21st March 2024. That is at page 158. Annexure 9.
Yes.
This is the interim order before the arbitral tribunal. The learned counsel for the petitioner stressed that so-and-so is an interstate boundary town of Assam and Mizoram should be graded as grade A and not B. The AR also pointed out that while fixing the market value of land registered sale deed from the area where land is situated, on average or the average price for similar type of land situated in the nearest village or nearest vicinity area or consented amount, that's section 26 of the Land Acquisition Act. Now, however, this was not followed by CALA, that's the competent authority, my lords, and also did not take the highest sale deed into account for arriving at the market value. This has drastically reduced the market value in so-and-so district. Now, my lords will just see the next part. In the course of hearing, the Kala Kosabi is directed to submit comments on an above claim of the authorized representative. If the claim of the authorized representative is correct, why Kosabi sale deed and the highest sale deed as claimed were not taken into account at arriving the market value of the land? That's the question posed to the Kara. Now at the very next page, my lords, is an explanation to that effect. There are no sale deeds to that effect. My lords has annexure 10 at 160.
Yes.
The relevant part is at 161. The market value of land was determined under provisions of Section 26 of Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act of 2013, wherein one of the three criteria is to be adopted. As the registered sale deeds were, this should have been not, my lords, were not readily available for determination of the market value of the land, the provision under 26(1)(b) was adopted. So there are no sale deeds. There is no evidence. And despite that, my lords, the learned trial court does not interfere. In this regard, now the methodology is explained, my lords. In this regard, 150 registered sale deed in such and such town area district headquarters were identified for determination of market value of the land belonging to a similar type of land in the proposed area of acquisition or near vicinity. The location of the sale deeds executed include so and so areas. CALA believes that the number of registered sale deeds is good enough for sample size and it would be indicated of actual prevailing market value. Now, in absence, well, Section 26 of the Land Acquisition Act very categorically holds that the test that is being applied by the arbitrator, that is the willing buyer purchaser test, well, that can only be applied when there is in fact an exemplar sale deed. There is no sale deed today before the arbitral tribunal. This order required, my lords, was to be interfered with.
So you
That's
mean to,
how my lords, the learned trial court.
so you mean to say you did not agree to the sale price, to the market value?
Yes, my lords.
Actually,
The test would not have been applied at all.
Just tell me one thing. This, you are on the price. The issue is of enhancement of the price. Correct?
That's correct.
Now, under section 34 or 37, what are the heads under which you can come in appeal?
My lords, one of the heads is patent illegality. I would just...
Sure, let us read it. Let us read it. Where does it say patent illegality?
Yes. My lords, it's referred to in the impugned order as well. Let
Give
me
me the
just
arbitration
refer
act.
to the last convenience as well. My lords, that's page 14 of the impugned order.
I am talking about the act.
Yes, my lords. It reproduces section 34.
Okay. Yes.
Para 21, your lordship has it.
Yes.
Application to set aside an arbitral award. Recourse to a court against arbitral award may be made only by an application for setting aside such award in accordance with subsection 2 and subsection 3. Subsection 2 is then reproduced, my lords. The arbitral award may be set aside by the court only if the party making the application establishes on the basis of the record of the arbitral tribunal, so and so, a party was under some incapacity, the arbitration agreement is not valid under the law to which the parties have been subjected, is or failing and any indication thereon under the law for time being in force. The party making the application was not given proper notice of the appointment of arbitrator or the arbitration proceedings or was otherwise unable to present his case. The arbitral award deals with disputes not contemplated by, not falling within the terms of submission to the arbitration, or it contains decisions on matters beyond the scope of submission of arbitration. Then it goes on, Millards.
No, so which part? So you are making the appeal under which provision?
Well,
which
patent
specific
illegality.
Huh?
Patent illegality, my lord.
Where is that? Where does it come? Under which one does it come?
Yes, I'll
It
just
comes
show
under 34 2A 1 2 3
Millards,
4 5 or
34
under B. Which one?
Millards, let me just show, my lords. My lords will just come to the first explanation to 34 2B. Explanation 1.
Yes.
For avoidance of any doubt, it is clarified that an award is in conflict of public policy of India only if the making of the award is induced or affected by fraud or corruption or by in violation of section 75 or 81. It is in contravention with fundamental policy of Indian law or is it in conflict with most basic notions of morality and justice? For avoidance of doubt, the test as to whether there is a contravention with fundamental policy of Indian law shall not entail a review on merits. Now, my lords will just have the Sanyong judgment. If I may show it on the screen, my lords, that's where the ground of public policy is being discussed.
Let us see.
This
What is
is
the citation?
Sanyong Engineering and Constructions Company Limited versus NHA.
Have you got a copy?
No, my lords, I'm not carrying the copy, so sorry.
My lords, if we may be permitted to share it on the screen.
I cannot read it on the screen. What is the citation?
My lords, this is 2019-15 SCC 131.
2019 15 SCC
131.
131.
Yes.
Para?
My lords, I am referring to para 31. That is at page 27. If my friend colleague can just broadcast it on the screen, it will show before my lords.
Yes, what does it say?
Yes, my lords. My lords, it actually goes on to explain the ground of public policy of India and what would be in violation of the fundamental policy of Indian law. And there, my lords, in para 31, it refers to the judgment of associate developers. It refers to the judgment of associate developers by the Honorable Supreme Court, and that categorically notes at para 31, the third juristic, I'll just read it out for your lordship's convenience. The third juristic principle is that a decision would be perverse or so irrational that no reasonable person would have arrived at the same, is important and requires some degree of explanation. It is settled law that where a finding is based on no evidence or that's part 1. 2. An arbitral tribunal takes into account something irrelevant to the decision whether it arrives at. Or 3. Ignores vital evidence in arriving at its decision. Such decision would necessarily be perverse and therefore contrary to the public policy of India. Now, my case today before my lords has been very simple. There is no evidence whatsoever, not even a single document, to establish the market value.
What was the market value given earlier?
My lords, in the original notification, the market value was given as, this is the notification of 10th January, my lords. It's reproduced in the award.
May I assist, my lord? For residential and habitat area, it is 106. For non-residential,
106 what? Per?
106 rupees per square feet.
Per square feet, my lords.
And for non-residential area but adjacent to national highway, it is 85 rupees per square feet. And for non-settlement bypass area, it is 64 square feet per square feet.
So 106 per square feet for residential
Residential habitat area.
Yes, that's page 121 of the.
That should be if the residential is habitat.
Yes, ma'am.
Then 85 per square feet for non-residential area.
Yes,
Yes,
ma'am.
ma'am.
But that's all.
And the third is non-settlement area, which is 64 rupees per square feet. My lord, this has been increased to 120 rupees for residential habitat area, then 100 rupees for non-residential area, and 64 rupees for non-settlement area.
My lords, will just find these values at page 121. That's the order of the Kala. Original values 121. Grade B notified towns. And the revised values your lordships will see in the impugned arbitral award at page 58.
No, they have it.
Mullahs, in fact, under 34(2)(a, the ground of patent illegality has now categorically been captured after the 2015 amendment.
Where have you read 31? Where have you read this part that without any evidence?
Yes, my lords.
Would come under this public policy. Where have you read
The
that?
patent illegality. My lords will just see this in the SCC version at para 24. It starts with yet another expansion of the phrase public policy of India.
Yes.
Contained under section 34 of 1996 Act was by another judgment of this court in Western Gate. Now, Mullahs will just turn the page and there is a quote from Associate Builders. Now, the Honorable Judge is quoting from Associate Builders, your Lordship sees. 28, then 38, 39, 40, 29, 30. Your Lordship sees equal treatment of the parties there. My Lords has it?
Yes.
Yes. Now, my Lords, 31. That's the next para after that.
Yes.
The third juristic principle is that a decision would be perverse or so irrational that no reasonable person would have arrived at the same is important and requires some degree of explanation. It is settled law that where a finding is based on no evidence, 1. 2. An arbitral tribunal takes into account something irrelevant to the decision. Yes.
Right. Heard, Mr.
Shubham Paliwal.
Shubham Paliwal, learned counsel
Yes,
for the applicant, who submits that there is a delay of 11 days in filing the appeal against the impugned
(23rd September 2024).
order dated Impugn judgment and order dated 2/9/25
25.
passed by the Court of the Additional District and Sessions Judge Aizol. Kolasip, in arbitration petition number 11 of 2023. So, on considering the grounds of delay, mentioned in the application, this court finds sufficient cause for the delay has been made out. Accordingly, the delay of 11 days condoned. I is accordingly disposed of. Then, in the main appeal, you write, heard Mr. Sensor, learned counsel for the appellant. The appellant's counsel has put to challenge the judgment and order dated 2/9/25 passed by the Additional District and Sessions Judge Kolasip, by which the appellant's appeal under Section 34 of the Arbitration and Conciliation Act 1996 in arbitration petition number 11 of 2023 has been dismissed. The appellant's counsel submits, next para, that the land of the petitioners, the land of the respondents had been acquired under the National Highway Act. What?
Yes,
National Highway Act.
Yes.
19 1956.
1956, my lord.
And as the respondents were not satisfied with the market rate, they were not satisfied with the value of land determined by Kala. CA.
Competent authority for land acquisition.
By Kala. The appellant and the respondents approached the arbitrator under Section 3G
Of Highway Act.
of the
National
Highways
Highway.
Act 1956. National Highways Act 1956. The appellants, Kala, the arbitrator thereafter enhanced the compensation amount awarded to the respondents without the same being based on any evidence. Also, the learned counsel for the appellant submits that the enhancement of the market value of the land of the respondents without being based on any evidence is in conflict with the public policy of India. In this regard, he has relied upon the judgment of the Supreme Court in the case of Sangyong Engineering and Construction Company Limited versus NHAI, reported in 2019 15 STC 131 at para 24 bracket 31, which states as follows. I put it here in this book, yellow. Issue notice returnable in 4 weeks. Appellant takes steps for service of notice upon the respondents within 3 days. This is the matter. Give a date.
Unless there is also a stay application since the direction have been passed.
No, then in the stay also, this, in the stay you write the same thing. And you say, give a date only. The stay will be taken up after notice.
Absolutely.
19 February.
Obliged, my lord.
Hey,